Land title of Central Florida versus Jimenez. You can begin when you're ready.
Good morning. Please the court. My name is Teresa Phillips. I represent the appellant, Land Title Central Florida, LLC, in this matter. I'd like to reserve 3 minutes for rebuttal, if I may.
Okay, I'll have to keep turn.
Do your best to speak up a little bit, okay?
Yes, sir.
Thank you.
I'd like to give a brief summary of what I think the key and, for the most part, undisputed facts were in this case, just to give the court a proper background of the argument we're making. In late 2003, the appellee and the plaintiff in this matter, ARELY Jimenez, contracted with a couple named Barbara and Billy Albritton to purchase some property in the rural area of Osceola County, Florida. The Albrittons owned quite a bit of property out there, and they entered into an agreement whereby they never gave a legal description as to the property. They contacted my client and used my client's services as a closing agency to close that transaction. It's undisputed that the property description contained in the deed was not the correct property description. It was, in fact, a description for another parcel of property the Albrittons happened to own. As it was brought to their attention, it became Land Title of Central Florida's responsibility to make sure that error was corrected. Now, the plaintiff filed a 5-count complaint, but only 1 count was directed toward Land Title, and that was a count for negligence, and negligently preparing the closing documents. It was relatively undisputed that there was a wrong description used, that at the time the complaint was filed, or the contract was entered into and presented to Land Title, there was no legal description. It was later determined that the legal description that was used on the survey that Ms. Jimenez obtained was legally insufficient in and of itself. So even if someone had been aware that they were using the wrong property, if they turned their attention to this property and the description that was provided, it was legally insufficient.
Well, Ms. Phillips, there's not a whole lot of question about that your client screwed up the
Absolutely.
Okay. So really what we're talking about is damages.
Absolutely.
All right. So why don't we short circuit? We all know what the facts are, so we can just go ahead and short circuit right to the damages.
I'd be happy to. Thank you, Your Honor. The basis of our argument is that the damages claimed at trial were not pled and should not have been trialable damages. The general damages from the alleged complaint and the actions that were complained of is the fact that she didn't have a good marketable title. She had a wrong property description. She didn't have good title of record. Those damages, that injury was corrected prior to trial. This is not a case where the closing didn't take place, she wasn't permitted to move in, her mortgage didn't close, so she was waiting to get another mortgage rate. None of those things happened. The transaction closed. There was just an error of record only. She moved into the premises. She testified she used it. The mortgage company had never caused her any trouble. They didn't proceed to foreclose because of the error. Nothing of those sorts. So we're just talking about an error on the record, which can be corrected by obtaining corrective deeds, paying the additional expenses that come along with that. Obviously, that plain title is Central Florida's responsibility, and they took care of that.
All these pleading rules have an underlying policy behind them. The pleading rule about pleading special damages is one of giving notice to the other side. Do you agree?
I do, Your Honor.
Did your client have notice that through discovery and pre-trial proceedings that the plaintiff was going to seek these types of damages?
We had notice of some of the damages. That's true. In discovery, there was a claim made for, I believe, 2 of the category of damages that we're complaining about today. One was the alleged interest that she would have saved if she'd been able to refinance. I believe there was some indication made in discovery of that. The other is her homestead exemption value. I believe there was some discussion in discovery on that as well. The mineral rights, the value assigned to the mineral rights, that was never brought up in discovery, never brought up in any proceeding prior to trial. In fact, I don't believe it was even discovered by the plaintiff by her own admission until a few months before trial.
Well,
we had absolutely no opportunity to be noticed on that.
She could not have discovered it until you sent her a corrective deed, right?
That was one she discovered when she sold the property, and that there was in the title search, because the original title search was on the wrong property, didn't note a mineral rights reservation.
You know, I went through the transcript of this trial, and I didn't see a single objection in there to the testimony about damages. Did I miss something?
In the beginning, there had been some discussion beforehand at pretrial, and we brought it up in our pretrial statements. The judge had indicated he wasn't inclined to believe they were special damages. I did make a note in my opening argument that we were going to object, and we had an objection to that. But recognizing the judge was probably going to let the testimony in, we had other arguments to be made. So we did make the objection. The judge also noted...
When the testimony actually came into evidence, you did not object.
I don't believe we had an objection
I
on
didn't-
every
I didn't-
opportunity, but I believe
I didn't
it was
find
a
any.
standing objection. It certainly was an implicit standing objection to all the testimony.
I'm not sure you can have
We
an
didn't.
implicit standing objection, but I when I read the transcript, I looked very carefully for objections, and I didn't see any. Am I missing something?
I cited to the page, I believe it was in my opening argument that I made that objection to the court. And the court noted in the motion for rehearing, at the hearing on that motion, that he didn't want to hear it on rehearing because he'd already decided that issue, and he didn't see them as special damages. He saw them as general damages. So to the extent that we didn't, the court wasn't aware of given an opportunity to address that, I believe it's clear from the record the court was aware of that. He just came to the legal conclusion that they were general damages, not special. Now, we've argued that all these three categories of damages are special damages, and I think it's clear when you look at the injury complained of that we used an erroneous property description, that obviously these damages do not naturally and absolutely, I believe the language is necessarily flow from that injury. We cited in numerous cases, some of which the facts are not directly on point. Quite frankly, I couldn't find one that had these exact same facts, but I did stick to cases that had factual patterns where the underlying cause of action is negligence. So that was what was pled by the plaintiff. I bring that up because I noted in the ARELY's brief there was a lot of reference cases that dealt with contract law and dealt with contract damages, foreseeability, and things like that. I don't believe that's applicable here because we have a negligence claim. All those cases are pretty uniform in their description of what constitutes special damages. It's something that may naturally or necessarily flow, but naturally flows, but not necessarily flows from the injury complained of. There's one case that talks about anything that the harm is contingent upon another fact other than the injury. That's by definition special. All of these damages complained of are contingent upon other factors. For example, the refinancing. In order for there to be any damage about refinancing, first of all, you would have to have been able to refinance. You would have had to have been eligible to refinance at a low rate. Lots more factors that wouldn't necessarily be in the case that every defendant in these same fact patterns. The value, the homestead exemption being the same thing. While I would concede that that's much more likely that almost any homeowner is going to be eligible.
That's probably the clearest one, isn't it?
I'm sorry?
That's probably the clearest one, isn't it?
It's one of the more that I think if you were guessing or trying to anticipate, you could come closer to anticipating that without any notice. But still, I don't believe that a defense counsel is charged with having to guess. They're not even charged with having to try the issues on what they know the plaintiff may seek. The Ephraim case is clear on that, and the court, even on a motion for rehearing, clarified that it doesn't matter what the defendant knew in discovery. They have the right to try the case on the pleadings as the issues put forth in the pleadings. The plaintiff didn't ever put these issues and these special kind of damages at issue in the pleadings. Had opportunity to amend at any time, presumably up until including the beginning of the trial, never did. The only claim was for a general claim of damages, and then there was one special damage claim, and that was for the loss of value of property, or loss of profit on a resale of the property. That became a non-issue because the property values increased so dramatically during this time period. She ended up reselling the property in another time for a much bigger profit. So that by the circumstances fell away, but that was a special damage that was pled in the pleading. The mineral rights reservation was the one that we took exceptional issue to because we had never even were given any indication in the pleadings. As we had indicated in the record, the defense counsel did not participate in the preparing of the joint pretrial statement, so we had no opportunity then to even learn that they had found out about this mineral rights reservation in the last year.
What is the causal relationship between the alleged mineral rights damages and the breach of the duty to prepare the deed in a non-negligent manner?
Your Honor, I believe that's a good question, and to be quite frank with you, I've struggled with trying to articulate what I believe the court was trying to rule. Based on Mr. Hand's argument at the motion for...
Well, take me back to the contract. If the plaintiff had a contract for sale and purchase, I guess. Is that in the record, the contract? Okay. Now, if the title company had discovered the existence of the mineral rights reservation prior to closing, what right would the plaintiff have had under the contract? Could the plaintiff have backed out of the contract?
Perhaps. I would have an opportunity to either rescind or renegotiate. I think that's what the court presumed, I believe, based on the argument.
Well, is the existence of the mineral rights, does that impede marketable title as defined under the standards in the contract for sale and purchase?
No, I don't believe it makes the property non-marketable.
Sounds like you don't know.
Marketable meaning that can you convey good title? You still own the property, you just don't...
Well, at least it seems that the plaintiff would have one of two options. If it did affect the marketability of the title, the plaintiff could elect to close and accept the encumbrance on title, or the plaintiff could elect to rescind the transaction or not close the transaction. And assuming that's the case, that election essentially was deferred until she finally got a corrected deed and a corrected title policy, but she apparently went ahead and elected to go forward with the transaction rather than rescind it, right?
Yes, Your Honor. Certainly, of course, at that point, we're talking about more than a year since she'd entered into the property. But you're right, she would have had an opportunity to rescind. The problem is there was no evidence put on of what her damages would have been if she'd been able to exercise that opportunity. The only damages she complained of was that she incurred additional attorney's fees when she resold the property, and that she reduced the value of the property to meet a buyer's demand. That's not evidence of what her damages were because she lost an opportunity to rescind. And again, we go back to, obviously, a lost opportunity is a special damage. That was not pled, and would have given us an opportunity.
Your client is a title company, right?
That's right.
So they wore two hats. They were the agent for the title insurer, and they were the closing agent for the transaction.
That's correct.
Right? The obligation to discover the mineral rights issue would have related to the provision of title insurance. Is that correct?
Yes, it's relating to the abstractor who did the title search, not specifically their role as a closing agent. I think you can make an argument. I mean, it really probably should have been a whole different pled count. It's a whole different theory of recovery. But all we would ask for is at least some notice that you were seeking these, and we could have explored those opportunities. I mean, this was the first time we had heard about this at trial, and really struggled with understanding why she felt that my client, in their role as closing agent in preparing closing documents, was responsible for $5,500 in damages she incurred at a subsequent closing. Again, if there had been some pleading, so we would know exactly what their theory is and exactly what kind of causal connection they see there, I'd be in a much better position to not only respond, but prepare for trial and prepare appropriate rebuttal testimony or whatever might be appropriate. This was a complete surprise. We pointed that out to the court. Court, I guess, inferring that he believed, again, it was a general damage, didn't believe it was needed to be noticed. But I think all of these damages demonstrate the need to plead your actions, plead for these special type of damages. Otherwise, you leave defendants guessing at what you're going to ask for, and there's no way that they can properly or fairly prepare for trial. Simple pleading would have
What was the nature of your objection at pretrial? Did you define which of the damages you were concerned about?
We said anything other than what was specifically pled in the complaint, which was the general claim for damages and then the loss of a sale opportunity that she had.
I don't want you to get away without talking about the attorney's fee issue. Would you like to jump to that?
Absolutely. There's no contract here, so by definition we don't have a contractual basis. So we're left to see if there's a statutory basis in which the court could award attorney's fees. The only statutory authority that was ever cited, I believe, in at the trial was 697.10, which is what I would describe as an obscure provision in the chapter dealing with mortgage and mortgage deeds. It does provide an award of attorney's fees by its wording for those that are harmed by the preparation of an erroneous or an instrument with an erroneous property description. It's found in the mortgage deed chapter. The title of the section is relating to mortgage deeds. We pulled up the legislative history to see what by instruments was meant by that. I believe it's clear, and I believe the plaintiff has conceded in their brief, or came close to conceding at least, that it's clear that it dealt with mortgage instruments. The intent described in the legislative history was that they were expanding the right to recover these damages. They didn't, and especially in the context of mortgages and balloon mortgages and that sort of thing. So I believe it's not instruments in general. I believe it's mortgage instruments. Now, granted, there was probably an erroneous description on the mortgage instruments as well. However, that doesn't cause any injury to Mrs. Jimenez, the plaintiff in this case. If anybody was injured by that, it was either the mortgage company or the other property owner who was having their property encumbered. Ms. Jimenez didn't show any injury because of an erroneous mortgage deed. No, the mortgage company didn't seek to foreclose on her.
Suit wasn't based on the mortgage. Suit was based on the deed. On the
underlying deed, the title. So you don't have a statutory basis for awarding those fees, and as the law is well settled, you have to have either a contractual or statutory basis. It was error to award those fees to Mrs. Jimenez in this case.
You're down to 4 minutes, but I'd like to hear your response to the wrongful act doctrine.
I'm sorry?
The wrongful act doctrine?
Yes, ma'am. I believe also commonly referred to as indemnification claim. As I read that for the first time in the answer brief, I would concede that it could be possibly certainly be made an argument here that those would apply to the facts. I think we would have an issue whether or not Ms. Jimenez was wholly without fault. She did have an opportunity to review the documents. She did not provide a legal description. She provided a survey that had an erroneous legal description. So we would certainly argue while she might not be the primary cause, she certainly couldn't be found to be wholly without fault.
Does the record show why the wrong legal description was used here?
No, I would say no. It was presumably negligence. We didn't really refute that. Obviously,
the seller had two pieces of property, and your client got the property description for one of them.
You can infer that, and since it's both the defendants, they just picked the wrong property. And I believe it was neighboring property, if my recollection is correct. But to get back to your question about the indemnification of wrongful doctrine, it was never pled. I believe it's true that you can, if the judge had wrongfully granted damages under one theory, but there was another available pled theory, viable theory, that he could have found damages.
Well, they did plead for attorney's fees, did they not?
They did make a basis for attorney's fees, but to be entitled to that, they would have to prove their indemnification claim. That's a separate or wrongful act doctrine claim. That was never raised in the pleading. That's just an element of damages.
You think that's a substantive cause of action, not a theory allowing attorney's fees?
I do. I believe that's an element of the damages.
Okay. Thank you.
Reserve the rest of my time.
Yeah, you've got about 2.5 minutes.
Thank you.
Good morning. My name is Ronald Hand, and I represent the original plaintiff in this case, ARELY Jimenez. And I would like to go back a little bit to the facts of this. We might be able to share that.
Could you help me out with the mineral rights issue?
I'll do my best. All right.
Well, I don't understand your theory. In other words, I understand that there was a breach of the duty, and I know what the duty was, and I know what damages would ordinarily flow from that type of breach of duty. But I'm having a tough time, I'm having a tough time bridging the proximate cause, element of a negligence claim.
Okay. And to answer your question, I would like to go back to the facts to show a little bit about that.
Answer it any way you have to.
What we ended up doing was, at the time when she got the property at the closing, she went back and told them that, excuse me, the title agent, you've given me the wrong property. And that was back in sometime in June, probably of 2003. And then she attempted to get them to correct this from that standpoint. At the time, she had a title policy on the wrong piece of property, a deed to the wrong piece of property, and did not have the correct piece of property.
All right, well, let me stop you.
And it was
Let
not-
me stop you there for a second, okay? If she had had the correct title policy, the abstract or whatever, and she had reviewed it, which under the contract for sale and purchase, they have to give it to her in advance of closing. She's got a right to review it, and she can determine whether there are defects that affect the marketability of the title. A
Yes, sir.
marketable title is defined under the standards on the back of the contract. Would this have been a defect in title, mineral rights?
It is my belief, under the contract, it would have been a defect that would have had to be cleared up, or at least disclosed to them relative to that, and then she would have had to make a choice as to whether or not she would have accepted the title that way, or there was a procedure, as I recall the contract, that would allow her, that is the plaintiff, or excuse me, the seller of the property, to correct that. That's the procedure. They can correct it, or that they can elect to accept it in that manner. And that could have also, while it's not in that portion of the contract, they could have renegotiated price at that point.
All right,
But without knowing that.
Okay, now let me ratchet you forward a little bit. So her right to do that was delayed, because rather than, she could have sued for damages at the point that she discovered that the deed was incorrect, and she could have got damages measured by the total purchase price. But what happened instead was that there was this attempt, or she could have got damages, and she could have hired a lawyer and got it fixed, and maybe got damages for what it cost her to do a reformation or what have you.
Correct.
But instead, it was fixed, and so her right to trigger the contract remedy was delayed.
That's our belief, yes.
All right. And once she got to that point of delay, now she's sitting there with a piece of property that's worth far more than she had contracted to pay for it. So I would assume that any reasonable person under those circumstances, for the sake of a mineral rights reservation, would elect, rather than rescinding the contract, would elect to go forward with it, which appears to be what she did, right? She accepted the deed and didn't invoke her rights under the contract to rescind the transaction.
That's correct. And there would also be other reasons that she had invested that are probably not a part of the record, but would be part of the facts of the case, is that she, in fact, as counsel has noted, took possession of the property. And she was there, and in fact, probably made improvements on it, and probably was in the anticipation that she was going to receive what she had supposed to have received back in 2003.
How about she did?
In 2005. After the filing.
I understand that, but if she had gone forward with the purchase in 2003 and everything had been done correctly, she would have ended up with a piece of property that had a mineral rights reservation on it. And in 2005, she ended up with a piece of property that had a mineral rights reservation on it. I'm having a difficult time seeing how she was damaged.
Well, the difference is that if she had known it in 2000, it's my belief, is if she had known it in 2003, she would have been able to have a remedy at the contract level with the vendor of the property as to what could be done with that reservation, either to have that eliminated as an exception to the purchase.
So
of the
that's
property.
not the kind of an exception that they can eliminate.
No.
That's not a cloud on title. That's a deeded right. So then the other option she would have had under the standards on the contract was to not go forward with the transaction, right?
Or be compensated for it. That's the other third alternative.
Sue the original vendor for damages.
Because of that reservation.
Well, why couldn't she do that now? In other words, why is the title company on the hook for that? She could go back to the original vendor and sue them for damages.
She could have done that. I don't disagree with that. But at the late hour that she learned about this is the reason we believe that was a damage that was normally that you would have expected to come out of this. There could have been other.
I don't see the causal connection, counsel, between the Scrivener's error on the deed and the mineral rights damages.
Well, as I believe that the causal is the fact that she did not have that information at the time that she accepted title of the property in the very beginning. This is something that came up. This is something that you would have, and there were other things that could have come up that did not. The vendor of the property, in the meantime, in my belief, could have sold it to someone else, which could have been an encumbrance, a problem relative to that. Now, it would have been wrong, and there would have been damages to get into the vendor, but this is something that the title company could have understood could have happened, that they would have had to correct. And it's something that would have come up, an issue relative to the title, a problem with the title that came up later would have been something that would have naturally flowed from their error that you would not have known about. And this is something that came up late in the game that they should have been able to anticipate at the time that this act occurred. And therefore, this is a normal damage that could have come from that.
But wait. Why didn't you plead it as a special damage?
At the point that it happened, the damage had not occurred. The special damage...
You have this thing called amendments, though. You can amend your complaint.
You can amend the complaint in most any time. But we believe, as the judge did in this case, that is not a special damage. There has not been a case that I found, or has been quoted by the appellant in this case, that says that type of damage is special. That is, that type of damage is something that you have to bring.
Would you agree that a special damage is one that depends on the happening of another event? It's kind of a contingent thing?
Sort of a third-party type of situation. Something else comes in.
Why doesn't that
is unique to the situation, unique to that person, unique to that plaintiff. That is something that is special to them that could have happened, that wouldn't have happened in just any circumstances or anyone else. And I don't believe that is the situation that we have here. That this is not a special damage that would have only uniquely come to that.
Well, if we disagree with you on that particular point, you lose on that issue.
Probably, yes. And I understand that. So from that standpoint, we believe that the problems that came up were because they took, at least part of it, was they took so long in which to correct the problem. They knew about the problem from within days of it coming up. And yet it took from 2003 to 2005 for them to correct the problem.
Right, and if the property had been going down in value, that may have been a real problem, but it was going up in value.
It was more of a problem for them probably than it would have been for my client. Certainly from a standpoint of the rise in prices, kept that part of the damages from being more than it was.
Can you help us out with the attorney's fee argument?
I beg your pardon?
Can you help us out with the attorney's
The attorney's fees argument, we believe, were based upon the facts of this case. And we believe that this statute permits the awarding, or actually says the awarding of the fees, based upon the incorrect legal description being contained in an instrument. And we would suggest to this court that this transaction had several instruments.
Is the statute ambiguous?
To my belief, I don't believe it's ambiguous. It says that that's what's happened. What I don't believe, it says that it is not, and as we look at what the legislative intent was, it uses the word deed. It uses the word mortgage. It uses the word instrument. And that's the type of thing that you're talking about.
If the statute is ambiguous, is there a rule of construction that applies that would militate in favor of the appellant?
From a standpoint, it's what the plain meaning is, I understand it. What you would reason.
Well, I mean, if the statute is ambiguous as to whether or not you're entitled to attorney's fees, do we go back to the American rule and you're not entitled to them?
I don't know that if it is ambiguous, I don't know that you go back to that. I think there's other theories of which attorney's fees could be awarded, which the judge could have used because we had asked for attorney's fees in this case. And I don't believe that we're required to specifically say at that point in time exactly what it is that we were supposed to get, how we were supposed to get our attorney's fees. And after the case was over and we went through that, we showed the basis of why that was true. Part of the argument that the appellant makes is that, well, listen, it was a deed, it wasn't a mortgage. But I believe the statute says an instrument, and it's fairly certain that this is an instrument. And in a closing transaction, the title company is given the responsibility of creating not only the deed, but the mortgages, the notes, and that's another item that would have been included in this. And anyone that is damaged by that, it's my understanding, their damages can be compensated by the statute, including the fees.
I thought you conceded in your brief that this statute was intended to apply to mortgage that instrument means mortgage, or mortgage deed.
It is, but my position is, Your Honor, that in this situation, we had a mortgage on a property that didn't belong to us. It was not properly mortgaged, and part of our situation is that we could not refinance the mortgage.
I understand that argument, but didn't you concede in your brief that this statute is intended to operate when there is an error in a mortgage deed?
I didn't read it to concede that. My belief was that I conceded that it would apply to mortgages, but I believe that it would also apply because this statute covers documents or instruments deemed a mortgage, which would have included a deed. And a mortgage deed or a deed are oftentimes two different things, but they do the same thing. It is a conveyance of the property. If you read .01 of the statute, it does talk about the situation that these are documents that conveyances would be instruments deemed mortgages. That's in 69701. All conveyances, obligations conditioned or defeasible, bills of sale, or other instruments of writing conveying or selling property, either real or personal. And it talks about these.
It keeps going on. It says, for the purpose or with the intention of securing the payment of money.
Correct.
That's a mortgage.
That's correct. But it talks about what documents or what instruments are used to be talked about as being mortgages. And I don't know that this statute tries to carve out and say, we're only going to talk about the mortgage.
All it says is all conveyances, obligations, and so forth, for the purpose of securing the payment of money, are deemed to be mortgages.
Correct. But they were describing, as I see it, they were describing what instruments could be mortgages. And it would, in this situation, it was not a situation where the title company only did a deed. They did a deed and a mortgage and a note.
You didn't sue on the mortgage and the note. You sued on the deed.
I sued on the transaction. The fact that they did not perform their duty to prepare the documents as instructed under the contract.
Did you seek a reformation of the deed, of the mortgage?
What we had said were whatever needs to be taken care of. I did not seek a reformation of the mortgage, no.
Did you plead the wrongful act doctrine?
The wrongful act? No, I did not plead that specifically.
Do you have to?
I don't believe that you have to specifically plead that. I believe that you have to show that that is something that the judge could have awarded your attorney's fees for, certainly. But I don't think that you have to specifically state that.
Did you read this court's decision in Southland Construction versus Greater Orlando Aviation?
I don't recall that one. No, I'm sorry. I do not.
Noted there that particular theory of liability, the wrongful act doctrine, had not been pled, and there was therefore no basis on which to assume it had any application.
I was relying on Caulfield, where it talks about the fact that if you ask for attorney's fees in this, it is not required that you specifically state what type or what theory it is that you're going to get. And that's the reason that we believe that we'd be entitled to the attorney's fees.
Okay, thank you, Ms. Jones.
If I may just follow up on a point that I believe was being made about the mortgage instrument here. The statute says someone damaged their title is impaired by the incorrect mortgage or incorrect instrument. If we construe that to mean mortgage instrument, which I believe that the law does support that construction of that term, Mrs. Jimenez her title was not impaired by an incorrect mortgage document. Anything, her title was benefited from the fact that she had a mortgage not on her property but on someone else's. She's not the impaired party in that circumstance.
Well, if the mortgage had been correctly prepared, then if it had the right legal description, then she wouldn't have been damaged, would she?
Well, she still the deed is what impairs her title. The fact that the mortgage document that encumbers her property has an incorrect title description only means that someone else's property is
encumbered. Well, if the mortgage had been correctly prepared, then the dissonance between the mortgage and the deed legal descriptions would have been apparent, wouldn't it?
I don't believe that would make it clear title. I believe you need a deed of conveyance. All that means is that somebody's encumbering or attempting to encumber that property. The question then turns on whether they have a legal ability to do that. It didn't impair her title. The incorrect instrument that impaired her title was the fact she didn't have a correct deed. The incorrect mortgage instrument impaired the other person's title that happened to own that property. That happened to be the Albritons in this case. Now, we secured their cooperation. We secured the cooperation of the mortgage company so that they didn't take any action against her for at least a brief period of time not having a good mortgage on the property that they were supposed to have a mortgage on. That was part of our responsibility. And I agree with, I think, a point you were making. In certain circumstances, in most circumstances, there could have been a lot of damages in this case. We worked to dispel those damages. We took efforts to cover the cost of most of the damages.
You took 2 years to correct the deed, and you're saying you worked to...
Well, there was a lot of evidence in her that there was reasons for that, not just because we were negligent. There had to be a new survey ordered because the survey she had obtained had an erroneous...
Didn't it take you months and months and months to even answer her letter?
It did before the lawsuit was filed. I believe there was some indication that there was a delay doing their investigation, that sort of thing, the title insurance company. I assure you, we worked diligently, and if she had been in damage, we would be responsible for those damages. If that property had continued to lose the value, if she truly lost a great opportunity, absolutely. If she benefited, that property almost doubled in value in less than 2 years.
So in a rising market, title insurance companies
We still have to prove damages.
you don't have a duty to do anything. You can just
Oh,
sit
absolutely.
around and wait.
If we hadn't corrected that title, we would be on the hook for $350,000. We made sure that that title was corrected of record, that she had good marketable title by the time she wanted to sell, and she realized the profit. That's just the fluke of the market. But you still have to prove damages. And the damages that were proven in this case were none. There were no damages that were pled and proven.
Thank you.